to Just Theory. In this episode, we speak with Heidi Hurd, who is Ross and Helen Workman Chair in Law, and the co-director of a program in Law and Philosophy at University of Illinois at Urbana Champaign. Her research spans areas of criminal law, torts, environmental law, environmental ethics, and moral, legal, and political philosophy. In this episode, we talk in particular about morality and the concept of mercy. We hope you enjoy. So, hi Heidi, we're delighted to have you here. Perhaps we can start by asking you why you chose to become an academic and why you've decided to stay in academia.
Well, let's see. The deeply personal answer to that question is that my dad was an academic. He was a political philosopher. But before that, he was a Missouri farm boy. And when he had a daughter, having been one of 5 boys on a Missouri farm, what in the world to do with a daughter? But he was a true philosopher. And so when I was about 4 years old, he started this tradition of taking me out on dates. And once a month, I would get all dressed up in a frilly dress, and my dad would take me out for dinner. And every dinner, he would teach me a new philosophical theory. So at 6, I was a phenomenologist, and at 7, I was a utilitarian, and at 8, I was an existentialist, and at 9, I was a Kantian. And he was just this incredibly gifted philosophy teacher to a very young child. And we did that all the way through high school. But he ultimately went back. He decided he became a university dean. Dean of Arts and Sciences. Of course, I became a dean, so following in his footsteps is very much baked into my biography. But he ultimately decided that being in administration took him too far from teaching and scholarship. And so he went back to law school. And so when I was 10 and 11 and 12, he was in law school. My mother was putting him through law school, having just been a university president before he stepped down and went to law school. And every night he would bring me in and give me a case for the day. And I remember sitting on his knee and having to solve the problem of Vincent v. Lake Erie. And now I teach torts, of course. And so I was destined to be a philosopher, a legal philosopher, a lawyer, and ultimately a university administrator as well as a professor. So, if there was ever a clone story, then it's my story, because I really did just completely follow in my dad's footsteps. So that's the sort of deeply personal reason. Obviously, I grew up in a very philosophical household, and so going in the direction of philosophy and then applying the lessons of philosophy to law and seeking out those areas of law that sort of wear their philosophical puzzles on their face, like tort law and criminal law do, was really natural for me. And so I gravitated towards those subject matters that really allowed me to exploit my background in moral and political and legal philosophy to the advantage of legal analysis and legal pedagogy. So, yeah.
Wonderful. It's I have to say, having read and having great privilege of reading your paper on the morality of mercy, that background of yours shines through in the paper. You can see this is a work not just of a legal scholar, but someone who's been interested in big philosophical questions for a long time. So I wondered if you could tell us a bit more about your work. Of course, we can perhaps unpack the paper in greater detail in a moment, but more generally, what kind of themes interest you?
Yeah.
You already mentioned tort law and criminal law as your key fields of research. But if you could tell us more broadly about your kind of philosophical and interest in what you work on currently.
So I really started at the beginning with some of the classic questions that almost always seem to animate people who get interested in the combination of law and philosophy. And those are the questions about the nature of law, the bindingness of law, and the relationship between law and morality. And so my earliest work, my doctoral dissertation that ultimately became my book called Moral Combat, was very much an inquiry into which wins when law and morality are in conflict. Can law ever command the immoral? Does it have the authority to give us reasons for action that would cause us to depart from what morality would otherwise require of us? And the answer in the book is no, 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 and hell no. So in some sense, I acquired an early reputation as sort of a new anarchist because I really don't vest law with anything more than theoretical authority. It's a guide, it's a help when it is, and when it's not, it's properly ignored. And so, there was sort of a radical rule skepticism underlying all of my early work. And you see that later in life when I write this article just, I don't know, 8 years ago or something called Promises Schmomises, where again, I'm very skeptical about the role of promises as rules given to yourself that bind you in the future to do things that at that time are ill-advised, are not all things considered justified. And so, rule skepticism and a distrust of authority runs through my work. I must say, it irritates the heck out of Michael that it doesn't run through my life. And he's always saying, you write all this stuff about how you're skeptical about the role of rules and the bindingness of rules, and you're the most rule-following person I know.
I was sorry to interrupt, but I had to say something because obviously I had wonderful privilege having that conversation back in Allerton with you about critical legal scholars. And I remember you've been quite skeptical about the inputs of the critical legal scholarship. So when you said you are a skeptic or skepticism informs much of your work, I was like, oh, so is it kind of Stanley Fish type of skepticism, or is it if it's not critical legal, what kind of school of legal thought would you associate your work with, if there is any school of thought that you could place yourself within?
Yeah, it's a good point, right? Because very often we think of critical legal studies in all its various forms as also being extremely skeptical, right? As taking power and politics to play a far greater role. The sense in which I differ from that is that I'm a moral realist. So I am not in the slightest bit skeptical about morality. And very often people who find their way in the Stanley Fishian direction or in the critical legal study direction, they tend to be moral skeptics as well, right? They often are relativists. Sometimes they're positively, they're deep-seated subjectivists. They're at least conventionalists, and I'm none of those things. I'm not a moral skeptic. I'm just a legal skeptic, and maybe the one fits with the other, because if you think that morality has a lot of heft, and it's a complicated system that speaks to most of our decisions in life, then you're pretty sure that law ought to be the handmaiden to morality, and you can be skeptical when law wants to depart from morality because you're not skeptical about morality's weight in our lives. I mean, I'm a thoroughgoing deontologist, and so in lots of ways, I don't share sympathies with all sorts of folks who otherwise would describe themselves as skeptics. But anyway, that was an early theme in my early work, and you can see every once in a while it recurring in much more recent work. But then I did, of course, as I moved into law teaching, I really did pick out the subject matters that, as I say, invited moral and political analysis. And of course, as I did that, I found all sorts of things to write about in criminal law and tort law. And what I particularly loved to pick out were topics that crossed the two and indeed crossed over to other areas of law as well. So consent, right? People often think of my work on consent, and I really only wrote a couple of pieces on consent. I don't think of that as being a sort of heavyweight component of my portfolio, but I know that a lot of people associate me with the consent literature, and consent's a really good example of a doctrine, as it were, a composite of doctrines, both in criminal law and in tort law, but it's going to show up in bankruptcy and tax and so forth. So I looked for topics like this that would cross over: self-defense, defense of others, necessity. All of those play a role in torts and in criminal law. So I was kind of looking for topics where, in writing about one, I was writing about both of my areas of interest and expertise. Then later in life, after I was a dean and I was ready to go back to being a faculty member, but I still hadn't scratched all the itches that caused people to, go be administrators for a while. And I certainly never wanted to be a provost or president. I didn't have a theory of what role those were that would make me good at them. But I decided to kind of branch out and I started to do environmental philosophy, environmental ethics. I taught environmental law a number of times, didn't care for the teaching of environmental law, but I still predominantly teach my sort of side course every year in environmental policy and environmental ethics. And I've written some in those areas. And that's taken me farther afield than I might otherwise have gone if I'd stayed just in torts and criminal law.
So it sounds like the paper that you kindly shared with us really speaks to the core of your research interests in terms of ascertaining the moral nature of mercy and how it pans out in criminal justice, but also how it differs from the kind of mercy we may show on an individual level. Could you tell us a little bit more about your argument? Just outline it for anybody listening. That would be amazing.
Yeah. And I guess as a preface to that, it is really funny. I wrote this early article on mercy that I'm kind of returning to for a chapter in a book that Michael and I are working on. And I wrote this article on mercy, and I'd written my article that was skeptical about promise keeping. And I had three of my colleagues who do bankruptcy law come into my office and they said, we're going to host a multidisciplinary conference on bankruptcy and we want you to contribute an article. And I thought, I never took bankruptcy law. This is how much I know about bankruptcy law. And I said, I couldn't possibly contribute an article. And they said, well, but you just wrote an article about promise breaking and you just wrote an article about mercy and there's bankruptcy. And I was so stupid. I went, oh, okay. And, I've got a book coming out of Oxford Press with a colleague of mine on the philosophical foundations of bankruptcy law that trades on, ultimately, it doesn't trade nearly as much as they thought it would, but it trades on, sort of when do we properly forgive people their debts in the context of bankruptcy? And when do we hold them to promises? Because promissory obligations, financial obligations are, of course, a significant component of the kinds of obligations we'd be waiving in the case of bankruptcy. So this stuff on mercy, even though it's really, in the context of the article, located largely within criminal law theory and the role that mercy might play and how it might offend against retributivist commitments, it turns out that mercy finds a whole nother face if you go over and think about forgiving people's financial debts rather than debts that they have in some sense accrued either to suffer or to pay back wrongs done to individuals in the criminal context or the tort context. But yes, when I wrote this article and as I rethink it for this chapter, I was fundamentally convinced for years, without spending a whole lot of time on it, that mercy was really problematically in tension with the retributivist commitment to guarantee people their just deserts, to never punish people more than they deserve, but to think that desert is a sufficient condition for punishment, that we don't have to extract any gains for ourselves the way a good utilitarian would have us do by punishing people. And it just struck me that if mercy constitutes, in some sense, a benefit bestowed without entitlement, and in the context of punishment, the benefit of alleviated punishment without entitlement, that certainly struck me as being at odds with giving people what they justly deserve. And so I was really interested initially in exploring the first question in the paper, which is, are there ever any contexts in which legal officials are entitled to lighten the punishment load of a wrongdoer when that wrongdoer's victim would, of course, both like corrective justice and be very happy to see that person receive the retribution that is their due? And of course, what I write in the article, and we'll get into it more, I'm sure, is I work through a whole bunch of reasons why all of us are sympathetic to officials using their discretion in ways that seem to be sympathetically motivated and in ways in which we're all sympathetic to. But of course, in each case, what I find is that they're not real instances of mercy. They're not real instances of utterly undeserved leniency. Then when I get to the personal side and I ask whether or not in our personal interactions, is it ever virtuous or vicious to bestow mercy on someone who has privately wronged us, right? And then again, there's lots of instances in which it doesn't look virtuous. Sometimes it looks positively vicious, but as the sort of buildup of the article takes me to the conclusion that in our very private and intimate relationships with friends, with partners, with spouses, you can't have love and friendship without mercy. You can't have love and friendship without undeserved leniency. And so there's a pocket, and it's an extremely significant pocket, in which mercy is the essence of the category, and that is love and friendship.
Thank you, Heidi, for outlining this article for our audiences. One aspect that did interest me in particular in the article is what you have already stressed here, is moral authority of state official to forgive or to be merciful. Do we have such, do the state authorities, judges perhaps, or presidents, if they pardon criminals, do they have a moral authority to forgive on behalf of the victim who has been wronged? So there is lack of this kind of correlation between them. Is there a moral authority for them to forgive? And I was wondering, conversely, looking at other acts of the state officials, like, do they have, if they do not, because if my understanding is correct, your conclusion is that from the retributive justice perspective, the state official has no moral authority to forgive, because the state official has no, again, this moral connection. Only the victim can really let the person off, so to say, for the wrongdoing. So my question was, where do state officials derive their moral authority to punish? Or to, is there, because there is also lack of connection between, so to say, the victim and the wrongdoer here, yet the state officials seem to have a moral authority to impose punishment. So I'm just wondering, what kind of justification do we find for state officials punishing on behalf of the victim and applying punishment, or the length, even the length of sentence, or determining the fate of the criminal or the wrongdoer? Is there a moral justification for it, or it's purely exercise of power or sheer power that a state official exercises when they punish a criminal?
Yeah, I mean, in some sense, that's a huge question, and it's certainly not a question in any way engaged by this particular article, because it is to ask, what's the authority of the state, and when does the state depart from its jurisdiction in which it can claim moral license as well as legal license to do what it does? I really do take law to be legitimate when it's in sync with, when it's in harmony with morality's requirements, both for offenders and for those who judge them. And so, I'm going to give you the most simplistic answer that would require a book-long, account. But to the extent that somebody is deserving of punishment, I take it that the state that articulated the conditions of wrongdoing to begin with, and if they did so properly, if the deservingness of punishment correlates with the articulation of a crime properly enacted by a just state, its officials are simply playing out the justness of the application of the law to the individual, the law itself being just by virtue of its correspondence with morality's demands. Put differently, morality speaks to officials as much as it speaks to citizens. And I take the authority of an official to derive from the morality that dictates the conditions of doing their role and doing it well. And so punishing those who deserve it as much as they deserve it, I take to be baked into a theory of criminal adjudication. They have authority because morality gives them that authority.
Yeah, this is what made me think about your specific, deeper moral question about justification, how to justify forgiving, or in this case, in the case of my question, punishing an individual. And if this is more about doing justice, and I think a lot of the points you make in the article boil down to delivering justice. If the response is just, then the officials have the authority to deliver that response, which made me think, how do we distinguish between the circumstances where forgiveness, so to say, is actually simply doing justice? Because in your article, you mentioned that, well, some individuals will, what happened, the reason why they committed a crime is a function of their circumstances, where they grew up, about their past, or about some genetic inclinations. So sometimes it's forgiving is simply taking into account the fact that the criminal perhaps didn't have the requisite circumstances, so to say, to refrain from wrongdoing. Therefore, we should take this into account and will be doing justice, as opposed to forgiving, or as opposed to doing mercy, because mercy is something, if I understood this correctly, again, in your view, mercy is about going beyond those deserts, so to say. So it's not simply responding to what the wrongdoer deserves, is actually being a bigger person and exercising that extra moral authority to do something that they actually didn't even deserve. So my question is, how do we draw the line between can we not collapse all cases to situations where wrongdoing is simply a result of some bad upbringing, or I'm
not going to follow you there, but you're absolutely right to pick out that one of the instances in which we are sympathetic to exercises of what some would call mercy are instances in which we think people have, as a moral matter, one or more excusing conditions. The criminal law is remarkably spare in its recognition of the excuses, right? There are very few excuses that allow people to walk away from criminal wrongdoing. But we might think that morality is more generous when it comes to sort of according people excuses for wrongs that they have done. And to the extent that judges are responding to morally valid excuses and reducing punishments in light of those morally valid excuses, then ultimately you're right. What I argue is they're giving people their just desserts as a moral matter, even if the law can't recognize the excuses that the judge is effectively recognizing in bestowing what, as I say, people call mercy. And I'm always going to put that in scare quotes, because that doesn't look like mercy to me. Anybody who's genuinely excused, partially or fully, for having done a wrong does not deserve punishment. And so if moral excuses are doing the work, then as a moral matter, they're getting their just desserts, even if the law would take it to be a departure from the excuses recognized under the criminal law. And the same is true of many of the other arguments that I explore in that context, right? I mean, we're really very happy when judges recognize that things went awry at trial, and they pardon or they commute a sentence. A governor issues a pardon, or there's a commutation of a sentence, where what surfaced is later DNA evidence that proves the person to have been innocent all along, or what surfaces that there was, bias on the part of the judge or other procedural improprieties. Well, then we celebrate again the exercise of so-called mercy, but of course, again, that doesn't look like mercy. That's just an official using their power, the power of their position, to actually get it right, to give the person their true just deserts when in fact they were overpunished in light of improprieties that happened at trial or subsequent evidence that since has surfaced. So yeah, I work through a whole bunch of reasons why we're sympathetic to people's sort of to leniency later bestowed. But every time we're sympathetic, it seems to me what we're always finding is that we're happy that an official has used his or her power to, in fact, deliver up just deserts.
But I wonder, so when I was reading your paper, especially around the distinction between the public and private dimensions of mercy, I started wondering whether mercy is a psychological state or if it can be a moral attitude. Because I think that would, in some ways, I'm not sure if we accept it as a psychological state, then I'm not sure if it would be compatible to begin with any institution being able to grant it. And I think somewhere in your paper, you do distinguish between acts of mercy and things like commuting a sentence, right? As those kinds of institutional acts. So I wonder whether we could dispose of the idea of mercy altogether in an institutional context.
Well, I'd be all for it because I ultimately think it's misplaced there. And I would think it's misplaced whether it's a mental state or an act, except what I do in the early part of the paper is, of course, engage the notion that when people talk about mercy as opposed to forgiveness, they really do take it to have both a kind of actus reus and a mens rea. Mercy, as typically referenced in the context of the criminal justice system, constitutes an act by an official that alleviates punishment, that accords leniency as a matter of sort of grace. And there's the classic, more biblical or religious context in which grace is sort of thought to be exhibited by an action that alleviates a burden in an undeserved way. But I think we also think that not only do you have to alleviate a burden, but you have to do it for a certain reason, right? I mean, if you're paid to do so, if it's an instance of quid pro quo, that doesn't look like mercy. That's just a pay-to-play deal, right? And so there are lots of unfortunate mental states that could accompany the alleviation of someone's punishment that we wouldn't think constituted an instance of mercy. So clearly we think the alleviation of punishment, if it's mercy, has to be done for a certain reason or with a certain mental state or attitude. And what is that? And it's not forgiveness, right? At least that's what I argue in the paper. It's not forgiveness because we can understand victims who actually appear in court and beg the court to be lenient to their own wrongdoers, even as they plan to nurse their resentment their whole lives against that wrongdoer. I remember years ago, it wasn't that long ago, but it was a number of years back where there were these ghastly murders of some Amish children. And the first thing that the Amish parents who lost their children did was argue for leniency vis-a-vis the murderer. But surely they weren't necessarily, maybe they were, but I mean, that it struck me as plausible for them to seek lenience for the wrongdoer, but to nurse their own ongoing anger and resentment in their hearts forever, namely not to forgive. And so it seems plausible that you could forgive and not seek mercy, or bestow mercy. You can bestow mercy and not be forgiving. And so something else constitutes the mental state of mercy besides forgiveness. And what I do in the article is explore a few other possibilities. In the end, it's plausible for somebody to say, well, mercy has to be an end in itself. It has to be the reason for which you act. The mental state that goes with mercy has to be the mental state of being merciful. But then, of course, what you have to do is go on and figure out, what is it? What is mercy? When is it justified? And only then can you piggyback the mental state atop it. And because I'm skeptical about its place in the legal system, I don't engage thereafter the mental state that would have to accompany it if it were legitimate, when I'm arguing it's not.
Just one more question about, so I have to say, I probably misunderstood or didn't read it the article correctly, because you distinguish between mercy and forgiveness as being two separate states. But if I could just clarify and go back to the connection between mercy and just deserts. So mercy is again, if I understood that correctly, doing something despite your deserts. So letting someone get away with a penalty despite what they deserve. But does it mean that in order to have a robust moral theory of mercy, we also need to have a robust theory of just deserts? And what kind of conduct actually ought to attract a punishment? So I don't know, historically, I don't know, having a wrong sexual orientation would constitute a wrong which deserves punishment. And today, perhaps we could be of a different opinion. So I just wondered what do you think? Because, especially given that you are legal realist,
moral realist, not a legal realist.
Moral realist.
Moral.
Not a skeptic. So is there a set of, so to say, I don't know how to put it, objectively wrong things that deserve punishment, and that remain so throughout history, so to say, universally wrong, and they universally will be eligible for mercy, if it makes sense what I'm trying to say. So is it easy to tell who deserves punishment?
No, clearly not, but there are also some clearly obvious instances. I mean, in some sense, again, this is the question you ask is a huge question, right? It's if you're an objectivist about morality, wherein does morality, reside? How do you know it? If it isn't a matter of social custom or convention, if it's not a matter of what individuals think, the way that a subjectivist would argue, wherein lies this sort of objective set of moral rules or principles that you're drawing on? And that's a much bigger, question than I could tackle here. But there are all sorts of instances in which we clearly are going to agree, right? Somebody who tortures somebody for fun, somebody who kills a child, somebody who rapes a child. We can name all sorts of obvious things, and it doesn't matter who you are and what your background moral theory is. You're going to be just fine with criminal law prohibiting that, and you're going to be just fine with the notion that people who do that within a just, an otherwise sort of just system are going to be deserving of punishment, right? And now there's all sorts of slippage, though, in trying to map a loss of liberty onto a wrong of one of those sorts. So why is it that, somebody who commits tax fraud deserves 7 years as opposed to 7 months as opposed to 17 years? Why does somebody who rapes deserve, 7 years as opposed to 17 years as opposed to 27 years? And the problem for retributivists has always been that if you're not literally extracting an eye for an eye and a tooth for a tooth, how do you map the extraction of liberty from a wrongdoer onto the wrong they've done and think you've got a principled match? And that's a hard problem for retributivists. And you might think that there's slippage in there that allows mercy to thrive, right? So you might think that if somebody who commits tax fraud deserves 7 years or 15 years, and both would be deserved as would everything in between, then it makes sense for somebody to say, well, mercy lives there. You could come into court and you could say, yeah, I'm deserving of 15 years, but I'm also deserving of 7 years, because what does it mean to map years lost onto, taxes not paid? And so, I'm pleading for mercy in the sense that I'm pleading for the lower end of your discretion about, how much suffering to extract from me for the wrong that I've done. And it's an interesting argument, right? But it's what it's really just playing on is not so much mercy and what it is, as the fact that every retributivist has got to have some sense that there's bandwidth in what it means to say a punishment is deserved, because it doesn't make sense to say that somebody who, steals a car ought to get 7 years and 37 days and 12 minutes, right? So there's bandwidth there, and you might think mercy lives within that bandwidth, but all it really is doing is picking out the fact that when you can't deliver up an eye for an eye, you can't literally match the penalty somebody has done with the penalty you impose. You can't match the penalty you're going to impose upon them with the harm they've done. Then you've got slippage to play with. But I don't think that gives much room for mercy. And I don't think that there's much room in there for skepticism about what counts as a wrong and where do you derive morality from and so forth. You can do all this at the 30,000-foot level, not the, 75,000-foot level.
To approach a perhaps smaller point that you made in your paper that really drew my attention, you talk about the relationship between the power and how retributive justice grants or restores a sense of power to the victims of crime. And I wonder how you would explain or your perspective on how that's compatible with state mercy. And it ties in to some of the aspects of the discussion that we had so far, but specifically on that point about power. To me, it seems like if we grant the state, or if we allow the state to grant mercy, I would imagine that would be separate from what the victims might think of that in some cases, right? So it's not dependent on this private dimension of mercy where a victim petitions an institution for mercy. It's more that the state has this, as far as I understand it in your paper, that the state has this kind of separate power to grant this, right? Wouldn't that interfere with that restoring power argument in some ways? Or maybe, because I know that as far as I remember, please correct me if I'm wrong, but I think you made an argument that mercy can restore power because it gives the victim the power to grant mercy. But it just doesn't, for me or in my head, in terms of retributive justice, it doesn't necessarily square up between those two dimensions. And I don't know how that conflict could necessarily be resolved.
Okay, good. Yeah, the exploration of that issue happens twice, because it does happen in the first section when I'm talking about whether or not victims, in some sense, ought to have ownership of whether they were wronged, how much they were wronged, and therefore ownership of the question of how much punishment ought to be inflicted on their wrongdoer. And I ultimately resist that. There are very famous retributivists, Herb Morris. There are very famous retributivists who've had what sound like corrective justice theories of retribution, namely the point of giving a wrongdoer his or her just deserts is to vindicate the victim. And then, of course, if vindication of the victim, if restoration of the victim to a position of moral equality with their wrongdoer, or what other metaphor you want to use to sort of capture the notion of vindicating a victim. If vindicating a victim is the goal of punishment, then notice you're going to punish when, but only when, and only to the extent that the victim needs you to punish to feel vindicated. And that has some unfortunate results for retributivists. Namely, you might not punish very much if the victim is saying, hey, I don't need to be vindicated, I'm fine. I guess you don't have much of a reason to punish the wrongdoer if they don't need to be punished to vindicate the victim. On the other hand, you could have a victim with sort of remarkable bloodlust, right? Who says, I'll only be vindicated if you do something dastardly to my wrongdoer. So the problem is that baked into the notion of vindicating a victim, it does not appear that there's either an accelerator or a brake to punishment. And I'm not a retributivist who's going to give victims ownership about whether they've been wronged or how much they've been wronged, and therefore ownership over whether their wrongdoers should be punished or how much their wrongdoers should be punished. And so that's the conversation that happens in the institutional context. And that does the work to say that victims don't own when and whether mercy ought to be bestowed. They can argue for mercy on behalf of their wrongdoers, but the state has no principled reason to let their determination, the victim's desires on that score, drive the determination of how much to punish or whether to punish. Now, at the back end, when you're just talking individual relationships, you and me, it may be true, right, that if you wrong me, then, the great thing about mercy is that it has this kind of delicious quality of being a form of power that can be exerted in response to a wrongdoer. So, Aleksandra, if you wrong me and then I get to say, here's mercy, I wonder if I will bestow it upon you, right? There's a real worry that mercy in the hands of an individual vis-a-vis another individual is not really mercy at all. It's this big old power trip, It's what was that famous movie where I'm gonna get it wrong, I'm gonna have a senior moment, not remember the movie or the actor in it, so I'm not gonna be helpful. But there are these sort of lovely moments in movies that explore how mercy, like the Roman emperor's thumb up and thumb down, doesn't look very merciful because it doesn't look like it's motivated by anything that we would consider an aspect of virtue, right? And so my question in the last half of the paper is, when is leniency towards another person who has done one wrong as an individual, when is leniency genuinely virtuous? And if people are doing this by virtue of it constituting a power trip, it doesn't look very virtuous, right? It might be happily received by the wrongdoer, but it doesn't look very virtuous. And the whole preoccupation of the second half of the paper is not with the question of whether one has a right to be merciful towards those individuals who have wronged one. I take it we all can be merciful towards those who've done us wrong. We can forgive them their debts to us. And we can decide not to sort of privately, socially punish them. The question is, when is it virtuous to be merciful in that way? And I don't take the emperor's thumbs up and thumbs down moments to be moments of virtue.
This is absolutely fascinating, the exploring different conceptions of justice and squaring them with the notion of mercy. So much of your paper obviously focuses on retributive justice. There are some elements of corrective justice. I wondered, is there any space in your theory for distributive justice, and how the relationship between distributive justice and mercy operates? Because I don't know, again, this is my exercise in imagination, but I could imagine distributive justice will be relevant when we think about perhaps rehabilitating the offender and thinking how can we make it, how mercy can be deployed for the social utility and the social good. So I just wondered if you can, I know that you do touch upon that slightly or a little bit in your paper. I don't think you use the expression distributive justice, though.
No, I don't.
So
That's a great question.
I just wondered if there is any space for distributive justice and mercy, and how that intersection works. If you had any thoughts.
Yeah,
Again,
I
my
love
thinking
that
was about the making mercy useful for the public purposes.
I love that question. Let me take it from the back end of the paper forward.
Mm-hmm.
On the back end of the paper, when we say, well, distributive justice between the three of us as friends, right? What would it mean? What would mercy look like in the context of distributive justice between a set of private individuals? It would look like a gift, right? If I were merciful towards you in a distributive sense, I'd be giving you a gift. I'd give you something you weren't entitled to, right? You don't have a right to a gift. You don't have a right to a piece of property, I'm going to give you this box, right? You don't have a right to it. But when I give it to you, I've achieved a distributive consequence. And I can imagine that if it is accompanied with whatever mental state we ultimately think corresponds with mercy, and that's just a big open question in the article, but whatever you would want to fill in as the appropriate mental state of a gift giver, I take it that would count as an instance of, a weird way to put it, but a weird instance in which, as a distributive matter, you're being merciful. I often think of sort of many of the biblical references, though, because if you think about sort of, I don't know, when Jesus Christ is desperately thirsty and he's carrying the cross, and the woman runs out and she tries to give him water. And it's an act of distributive mercy, right? He needs something, she has it, and it's complicated to get it to him. It's going to take sacrifice on her part. Um, and that's sort of classically thought to be a lovely instance of mercy. It's the kind of mercy I talk about at the beginning of the paper that isn't relative to criminal law. No surprise, we're not talking about criminal law anymore. It's a kind of gift giving when it's a genuine sacrifice on the part of the person who parts with it, or she, you know, she sort of
So,
invites peril, right? Now, in the institutional context, I don't know what mercy looks like in the institutional context, right? So when tax lawyers and tax theorists are sitting around trying to figure out how to reallocate wealth to achieve greater distributive justice, I doubt that there's a place for mercy, because every time they think that they would want to transfer something from those who have to those who have not, they probably believe that in doing so, they're not perpetrating a wrong in order to transfer something that's unentitled. I think they think they're getting the entitlements right, that those who have properly shouldn't have that much, and those who don't have properly should have more. So it's really hard to figure out how, in the institutional context, mercy or its cognate would ever have a role to play when you're reallocating society's resources and trying to get the distribution more fair or more just in light of whatever your theory of distributive justice is.
so when I was trying to look for a correlate, so to say, in tort law for mercy and situations where perhaps the deserts do not necessarily correspond to the wrongdoing, I was thinking about cases of joint liability, or cases where you have deep pocket defendant taking greater burden for the wrongdoing, or cases where you've got evidential gap, like asbestos litigation,
Yeah.
where you do not really know who had caused the damage, but it is distributively just to allocate that, so to say, the burden for the wrongdoing for the deep pocket defendant, whom most likely have caused the damage. But then again, is that a case of mercy, or is that simply redistribution in a way that the society deems just? So that's why that's what made me think, or is there anything equivalent where deserts do not correspond to
It's a really good question, because there again, I mean, either we just ultimately think that as a matter of distributive justice, that's the second best solution once an accident has happened, where the first best solution was that it didn't happen at all. But alternatively, of course, it's a classic instance in which you think the greatest good of the greatest number is being served, and you're willing to take from those who have and give to those who have not, because given the diminishing marginal utility of wealth, you're going to get increases in utility by making those transfers, or you're simply allocating burdens in light of what will maximize the good summed across all, and you're just being a good utilitarian, which again, in the article I reject as giving you much of a theory of mercy at all, right? You're just being a good utilitarian. Both things of which are worthy, but neither of which count as mercy.
Before we wrap up this super interesting conversation, maybe a slightly different question. What are some of the questions that you are still grappling with in drafting that chapter?
Okay. That's a really interesting question, because one of the things, so I'll give you what I take to be the harshest criticism. And that is that there's, in the end, all I do is dissolve mercy altogether. I'm not left basically with any, certainly in the institutional context, right? And so somebody could say, look, every time I give you a good reason for mercy, you tell me it's not mercy. To which I go, yep, right? Every time you're sympathetic to somebody getting some reduced penalty or reduced liability, well, that's not mercy if it's justified. And if it's not justified, then mercy isn't justified. And there's a sense in which the article dissolves the very phenomenon that it explores. Now, it doesn't, when you come to the reason I take the end of the article to be so important is that at the end, I'm not skeptical at all about there being something that amounts to mercy, and it being absolutely critical. And so, we will all do wrongs to our loved ones. We will all wrong our friends, and we will all wrong our spouses and our loved ones, sometimes in big ways and sometimes in little ways. And love and friendship cannot exist, let alone survive, if we aren't willing to lift punishment, to alleviate penalties when those in fact are deserved, right? And so I find mercy very much alive and well, and indeed constitutive of the most essential relationships we have in life. And therefore, I clearly think it amounts to something. I think it amounts to undeserved but well-motivated alleviation of another's penalties, liabilities, suffering, and so forth. But I only find that it has room, and is justified in that incredibly circumscribed arena of private relationships. So I don't dissolve the phenomenon altogether, but I dissolve it in the institutional context, because every time I find that mercy has some sympathetic ear in the institutional context, I'm going to turn around and tell people, yeah, and then it's not mercy at all. It's just giving people their just deserts. And so there's a sense in which people are frustrated by the fact that it just goes away altogether in my hands in the institutional context. And they don't mind my rejecting it, but they don't want me to absolutely eliminate the very phenomena. I think that's something to really be grappled with.
For what it's worth, and I wonder, Emilia, what your thoughts are. Like, to me, that makes a lot of sense. But then again, I am not too fond of extending concepts too far, even if we may like the softness and the fuzziness that comes with a word or a concept of mercy. But I don't think that necessarily always justifies implementing that concept or trying to force that concept into the public sphere without revising certain underlying assumptions about it, right? So to me, at least, the very core, and it sounds like it's not that dissimilar to what you say in your paper, at least in my reading, is that there is a very core of this relational, it's not forgiveness, but it's like, I'm granting you something for free, and it's very relational and it's personal, and it doesn't come from some sense of, it comes from a different sense of justice than what we might see in an institutional context.
Yeah.
So
yeah, I can live with it going away in the institutional realm. I guess that's sort of my point, right? I argue for that. It's just there's no there. There's no
yeah.
plausible place for it in the context of the criminal justice system. And I can live with the fact that people are frustrated by their sympathy towards the notion of mercy. Jerry Postma, in his new book, has a whole chapter where he takes mercy to be integral to justice. And I couldn't be farther removed from him when it comes to finding no place for it all as opposed to it being integral. So there's clearly an enormous debate there between those who, like Jerry, think that it's core to justice, and me, who thinks that it's absolutely antithetical to justice. And you can't talk about the two in the same breath or the same paragraph or the same system. So yeah.
Just to answer Aleksandra's kind of provocation, again, I don't have the answer to it yet. I didn't make my mind yet as to whether, in my mind, there is some space for mercy in the public
we'll show you
sphere.
mercy, Emilia. It's okay.
Again, perhaps we can play a little bit with language and with separate words that seem to be reserved for the expression of clemency being the official kind of expression and mercy being much more kind of private sphere thing. I didn't give it enough thought, I must say, but I'd be very curious to know what Heidi thinks about the clemency versus mercy, or they are one and the same kind of thing.
Yeah, I mean, some of those terms are just terms that are role relative. There are certain kinds of people occupying certain roles in which we talk about them as having the power of clemency. Many times, of course, they're anxious to be good utilitarians, and properly so. they're anxious to exercise clemency in circumstances in which it will, maximize social welfare or the interests of their constituents and so forth. And those are all perfectly good reasons for clemency. They just aren't, in my view, very often merciful. And if they are merciful, then I'm taking them to be very suspect, because then somebody who doesn't, in fact, as you started us out with, doesn't have sort of the moral authority to stand in the stead of the victim, nevertheless is purporting to do so and relaxing a punishment that they have no business relaxing. And then I think it's morally suspect.
There's certainly a lot of thought to digest for us and for our audiences. Thank you so much, Heidi, for joining us for this wonderful conversation. It was absolutely wonderful and thought-provoking.
Well, you're welcome, and thank you for provocative questions. Send me back to the drawing board. Appreciate it.